So now we go to remedies on local government code and customs code. Now we first go to section 174. In section 174, the local government units have what? The civil remedies. They may either distrain, levy, collection suit, and just like in the NARC, these may be availed of simultaneously. I take note of section 185, personal property exempt from distraint or levy. So you familiarize yourselves with that. And as we discussed earlier, section 187 is all about approval and effectivity of tax ordinance. So we go there. Okay, this one. Procedure for approval and effectivity of tax ordinances and revenue measures. Mandatory public hearings. The procedure for approval of local tax ordinance and revenue measures shall be in accordance with the provisions of this code, provided that what? There's a public hearing. Okay? Shall be conducted for the purpose prior to the enactment thereof, and provided further that any question on the constitutionality or legality of tax ordinances or revenue measures be raised on appeal within 30 days from the effectivity thereof to the Secretary of Justice, who shall render a decision within 60 days from the date of receipt of the appeal, provided, however, that such appeal shall not have the effect of suspending the effectivity of the ordinance and the accrual and payment of the tax, fee, or charge levied therein, provided finally that within 30 days after receipt of the decision or the lapse of the 60-day period without the Secretary of Justice acting upon the appeal, the aggrieved party may file appropriate proceedings with a court of competent jurisdiction. I think this provision was, or there was a question in the bar concerning this provision last year. So you remember that, oh, well, there's this case, Cagayan Electric versus City of Cagayan, and it was stated there that clearly the law requires that the dissatisfied taxpayer who questions the validity of the legality of tax ordinance must file his appeal to the Secretary of Justice within 30 days from effectivity of such ordinance. Okay? In case the Secretary decides the appeal, a period of also of 30 days is allowed for an aggrieved party to go to court. But if the Secretary does not act therein after the lapse of 60 days, a party could already proceed to seek relief in court. These three separate periods are clearly given for compliance as a prerequisite before seeking redress in a competent court. Such statutory periods are set to prevent delays as well as enhance the orderly and speedy discharge of judicial functions. For this reason, the courts construe these provisions of statute as mandatory. So you take note of the prescriptive period there. Now, but there are exceptions, okay? There is this exception. Nevertheless, in later cases, the court recognized exceptional circumstances that justify non-compliance by a taxpayer with Section 187. So, as early as on Ongsuko versus Malones, and there's this case, again, this Alta Vista Golf. You just remember that a case where the issue raised is purely legal question, well within the competence and the jurisdiction of the court and not the administrative agency, would clearly constitute an exception. So if the question posed is purely legal, not question of fact, then that is the exception. Okay, so remember, the rule is you have to follow the procedure in section 187 in assailing the tax ordinance. Okay, because if, well, you have to, you have to differentiate the question of fact and the question of law. So if it involved even an iota of a question of fact, then you have to comply with section 187. The exception again, if Alta Vista versus City, or if there is a question of law, then you can go directly to the court as provided in Alta Vista Golf or reiterated in Alta Vista Golf versus City of Cebu. What was, as mentioned earlier or discussed earlier, this is all about the amusement tax. So you don't, there is no question of fact there. So that is the section 187. So you take note of that. It is, the provisions therein are mandatory. And okay, taxpayer remedies, period to assess within 5 years from due date. Okay, You cross-read that with Section 139, 161, 167, and 249. And in case of fraud or intent to evade, 10 years from discovery. Period to collect, that's 5 years from date of assessment. So you have 5 years to assess the treasurer or local government unit, and you also have 5 years to collect date of assessment through administrative or judicial action. So you may, well, simultaneously avail of that. And the suspension, just like the tolling of prescriptive period, the treasurer is legally prevented and the taxpayer requests for re-investigation. Okay? And, okay, this protest of assessment, Section 195. As we've discussed in Yamane versus Lepanto earlier, or when you were still, again, lost students, I've emphasized that what is stated in Section 195, okay, let's go there. Here, this one. The taxpayer shall have 30 days from receipt of the denial of the protest or from the lapse of the 60-day period prescribed herein, within which to appeal with the court of competent jurisdiction. Otherwise, the assessment becomes conclusive and unappealable. The Supreme Court in Yamane versus Lepanto said, well, the appeal partakes of the nature of what? An original action before the RTC. Because, or before the court. Because why? The treasurer is not vested with judicial power, so there is no appeal there. Although the law says appeal, but it's not in our, as a student of law, you should know that an appeal partakes of a judicial action. If the decision there does not involve a judicial procedure, then it's not really an appeal insofar as the rules of procedure is concerned, such that it is, as stated in Yamane, it partakes of the nature of an original action. But this was, well, it was reiterated by a recent case, China Banking Corporation versus City Treasurer of Manila, where this involved the jurisdictional amount. Okay, so the court there said, as we've discussed in Yamane, the appeal partakes in nature of original action, but it's not really before the RTC because the courts have jurisdictional amounts, so RTC, MTC. So the idea here, if there's a question, you must memorize the jurisdictional amount. In China Banking Corporation, what was involved there is, how much was that? I think it doesn't exceed the jurisdictional amount under the MTC, but they appealed that, or China Banking Corporation appealed that, or filed an action before the RTC. So wala gyapon. But so you just remember, if the question is asked what is the nature of the appeal, then you take note of Yamane, because here, as stated in China Banking, it reiterated Yamane. Okay, so remember that. What are the other provisions? Claims for tax refund or tax credit 2 years from date of payment. This is in writing, class. Section 196. And again, in Section 196, 195, and 194, that's the word assessments here is different from the word assessment in real property taxation. Okay, you must remember that, or you must take note of that. And okay, in remedies in Section 226 for real property taxation, you may appeal the assessment. Oh, this one. This comes from the city assessor, not from the city treasurer. Now, you may appeal the assessment. You remember the Manila Electric Company case where the assessor, after declaring the properties of the Manila Electric Company to be taxable under a tax declaration, he issued an assessment. He assessed how much was the value of the machinery. But if you have an issue there, you can go to the local Board of Assessment Appeals within 60 days from receipt of the assessment from the assessor. And this assessment, as I've said, is different from the assessment made by the city treasurer for deficiency or treasurer for deficiency tax. Okay, and in section 229, actions by LBAA should act within 120 days from receipt of appeal, and you can appeal that ruling if you receive 30 days from receipt of the decision to the central of Central Board of Assessment Appeals. And the CBAA are, or decisions of CBAA are final and executory. You can elevate the matter to the CTA via Rule 43. And okay, in section 252, well, by now you should know this, that in real property taxation, this is quite distinct provision because your protest will not be accepted or will not be considered as a protest if you will not pay under protest. You have to pay before you can protest. That is the rule in real property taxation. It is not, the business taxes are not covered by this. So it is only found in real property taxation. But is a bond, the posting of the bond enough? There is a case here that posting of a surety bond is substantial compliance. Instead of paying it in cash, you can pay that in through bond, surety bond, as decided in Manila Electric Company versus City Treasurer or City Assessor and City Treasurer of Lucena. So remember that if there's a problem and there's a question about this, then the payment of surety bond is substantial compliance. Okay. And section 261 and 263, redemption and purchase of property by LG of one for one bidder. You take note that the 1 year prescriptive period or redemption period starts from the date of auction sale. Okay, what this is a case of, I think this involved a property in Davao, the estate of Amado Dalisay. Now, well, if you've been to Davao, the Dalisay property is somewhere in Bahada where the Apriza Mall and a host of other properties. But this one, this is different from the 1 year redemption in your commercial law class. Okay, remember, 1 year redemption period in commercial law says that 1 year redemption period starts from the annotation of the certificate of sale from the on the certificate of title. But if it involves a bank, the lender, and a juridical personality, then there's a different period. I think it's 90 days if I'm not mistaken. Or upon the issuance of the certificate of sale or upon the annotation. So you just remember this is different. 1 year redemption period starts from the date of auction sale. So no, because in the Lisai heir said the owner, or they claim that it should be upon the issuance of the forfeiture, not from the sale. Because what happened here was it took 1 year from the date of sale for the issuance of forfeiture or the forfeiture certificate was issued. Nangasaba ang Supreme Court ani. Therefore, in cases covered by these pertinent provisions in the local government code, the date of sale or forfeiture is rightfully the point in time when the owner is divested of certain attributes of ownership over the property, albeit only until the redemption of the property. This translates to no other event but to the date of the public auction. So, again, you do not count the redemption of property or the redemption period from the date of the annotation of the auction sale in cases, okay, I repeat, in cases of local government taxation. This is different from when a bank or a borrower or a lender for extrajudicially or judicially forecloses a security, real estate. So that's it for the remedies. I hope you have. We'll discuss more on this when I'm there. I hope you have mastered the remedies. But just remember section 187, okay, and this one, the protest of assessment. the nature of the appeal. It's not really, it's not always in the RTC because it is below the jurisdictional amount of RTC, then you go to what? TC. Okay? But it is not an appeal. Again, if you're asked, the treasurer is not vested with judicial power. So there's no appeal there. It partakes of an original action. And also, what are the others? This one, you must master this. And payment under protest. Remember, posting of surety bond is substantial compliance. You don't have to pay in cash. And redemption 1 year from the date of auction sale. Okay. So next we will discuss some remedies in customs, and last the Court of Tax Appeals.